Hello, everyone. This is Eric Eisenman, the leader of Husch Blackwell's National Labor and Employment Practice. I am a partner at the firm and am located in our office in Milwaukee, Wisconsin. Joining me today is my colleague, Skye Parr. Skye is a resident in our Madison office and also an attorney in our Labor and Employment Practice group. Skye and I are excited to be talking with you today about recruiting and retaining diverse employees and how to achieve those goals without running afoul of state and federal anti-discrimination laws. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I'll take just a minute to highlight a few of those key icons for you. If you have any questions during the webcast, please submit those questions via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, we'll try to answer that later via email. We do appreciate audience participation and encourage you to submit questions there. There is also an icon to assist with your viewing preferences. You can expand your slide area by clicking on the maximize icon on the top right of the slide area or by dragging the bottom right corner of the slide area. If you have any technical difficulties, you can click the help icon. It has a question mark and it provides information regarding some common technical issues. A copy of today's slide deck and any additional materials are available in the resource list icon that looks like a folder at the bottom of your screen. This program has been approved for Colorado, Illinois, Iowa, Kansas, Minnesota, Missouri, Nebraska, Tennessee, and Texas continuing legal education credit, as well as HRCI and SHRM recertification credit. Wisconsin CLE credit is pending. The program has also been approved by the Illinois Bar for diversity and inclusion credit and by the Missouri Bar for the elimination of bias credit. To report your HRCI, SHRM, or CLE credit in your various states, you can click on the CLE widget at the bottom of the screen and complete the questions. You can download the certificate of attendance from the certificate widget at the completion of our program today. A recording of this webcast will be available tomorrow for watching and sharing. Once that's available, a link to the recording will be emailed to you. So now that the housekeeping items are out of the way, and before we get into the substance of our presentation, I wanted to take a minute to address the events that have taken place in our country over the last several weeks. Skye and I have had a series of conversations about how this presentation topic relates to the larger discussion that's going on right now about the systemic racism, injustice, and discrimination that Black Americans continue to experience. Those are big structural issues that we all need to confront together. But there are related issues that all of us here on the webinar today, by virtue of the positions that we hold in our businesses and our law firms, are uniquely positioned to address. As labor and employment lawyers, Skye and I are in a position to help our clients develop and implement employment policies and practices that acknowledge and address the racism and bias that still exists in the workplace and in our society. And many of you that are listening are in a position to actually make changes in your organizations to address those problems. So we hope that the discussion today about strategies for recruiting and retaining and valuing your diverse employees will give you some of the tools to begin that work. With that, I'll move on to just a brief overview of the items that we plan to discuss. As you can see from the agenda here, we'll start in chronological order by focusing on the recruitment and hiring process. Skye will talk a bit about strategies and techniques for attracting diverse candidates, as well as interviewing diverse candidates, which will include a discussion of some do's and don'ts in that interview process from both a practical and legal perspective. We'll then segue into a discussion of the applicable legal framework that's in place here, the anti-discrimination laws, as well as a discussion about potential reverse discrimination claims and some advice on how we can mitigate our risk or avoid those. And then finally, we'll talk about strategies, both legal and practical, in retaining and assisting in advancement for diverse employees, which will include combating turnover. So with that, I will turn the slides over to Skye.
Thank you, Eric. Good afternoon, everyone. We're going to start our presentation with the definition of diversity. The Department of Sociology at the University of Washington defines diversity as the social categories like race, ethnicity, religion, gender, sexuality, socioeconomic status, nationality and citizenship, veteran and parental status, body size, ability, age, and experience. These categories, the meanings and significance of which intersect, change over time, and vary by context and situation, are profoundly important aspects of people's identities and lives. Such social differences are the foundation for a diversity of perspectives that enrich our businesses, our professional and personal lives. Diversity has a different meaning to everyone, and your business or firm may choose to adopt a broader definition than what is set out in this slide. At its core, however, diversity is variety. It is differences, both individual and group social differences. So how important is diversity? It is extremely important. 67% of job seekers consider workplace diversity an important factor when considering employment opportunities. More than 50% of current employees want their workplace to do more to increase diversity. 72% of women, 89% of Black Americans, 80% of Asians, and 70% of Latinos rank workforce diversity as important in their job search. But we can't have diversity without inclusion. Inclusion is a process. It is a process that enables the full participation and contribution of all human resources in support of the mission of your organization. It's listening to the point of view from someone different and considering it in order to think and perform better. Inclusion is involvement and empowerment where the inherent worth and dignity of all people are recognized. Fundamentally, people just want to belong. They want to be heard, understood, and included. What we know is that while a truly inclusive group is necessarily diverse, a diverse group may or may not be inclusive. Leveraging the diverse talents, skills, and attributes of your workforce through the process of inclusion is vitally important. The Office of Personnel Management administered a survey assessing the extent that employees feel engaged, supported, and motivated. The team came up with 5 habits of inclusion. These habits encompass behaviors that advance employee engagement and include being fair, the ability to exhibit a disposition that is free of favoritism and bias, open, the ability to be free of a closed mind, receptive to new ideas, viewpoints, and people, cooperative, the ability to help others in a positive way, supporting, the ability to compassionately care for others, and empowering, the ability to help others contribute to their full potential. Understand that inclusion is not synonymous with agreement, nor does it mean consensus. So inclusive, intelligent is not thinking alike. It means that differences of opinions can coexist. Simply put, the presence of a diverse individual is not enough. You must make an effort to use the 5 habits of inclusion to integrate them into the company. So how does diversity and inclusion impact revenue and profits? Racially and ethnically diverse companies are 35% more likely to perform better. They are better positioned to capture new markets. Diverse management boosts revenue by 19%, and diverse companies enjoy 2.3 times higher cash flow per employee. Diversity fosters innovation and creativity through a greater variety of problem-solving approaches, perspectives, and ideas. A partner at an AmLaw 50 law firm stated, "A demonstrated commitment to diversity and inclusion can be a key aspect of a law firm's competitive advantage when it comes to recruiting and retaining talent and pitching certain clients. Clients receive the highest quality service when their legal teams are drawn from professionals mirroring the diversity of the marketplace." So we have, now we're going to ask you all a poll that how is diversity and inclusion being instilled in your organizational communities? Is it by enrolling in a diversity-minded program, hosting a diversity career fair, offering an employee retention bonus, all of the above, or none of the above? Take a second to answer the poll right now. As we can see, there are some companies on the call today that are utilizing these diverse recruitment strategies, such as enrolling in a diversity-minded program. However, I am going to urge companies to utilize them all. So now that we've gotten the definition of diversity and inclusion out of the way, we're going to begin to talk about attracting diverse candidates. First, you can establish a diversity brand via social media, your website, print materials, and people value storytelling and authenticity. Tell individuals why and how you're supporting diversity. Enroll in a diversity-minded program. A lot of people have stated that they have already done so, but I want to urge the rest of the callers to do so as well, such as through the Human Rights Campaign or the Corporate Equality Index, to keep yourself accountable to these promises. Job postings. Reconsider job descriptions and search methods. Consider using software that helps make hiring less gender biased by removing names and other identifying factors. Consider using wider ranges in job descriptions. Women apply to 20% fewer jobs as compared to men. Women are more likely to apply only when they feel that they meet 100% of the requirements, whereas men will apply after just meeting 60% of the requirements. It has been found, additionally, that hiring managers are more likely to click on the male candidates' profiles or job descriptions. Lastly, consider if the position can be remote. Because of COVID-19, remote work has broken down location barriers, which has resulted in exponentially expanded applicant pools. It is important to note, however, that recruitment efforts must be supported by inclusivity. Utilize internal-facing initiatives. Utilize your employee network by offering an employee recruitment bonus. Employees are a great resource to find new talent. Partner with diverse student professional organizations, such as the National Black MBA Association, Inroads, American Corporate Partners for Veterans. Host a diversity-focused virtual career fair, such as there are a couple going on, such as the Bender Virtual Career Fair, Veteran Recruiting, but you can also create your own. Companies such as Cisco, Amazon, IBM, 3M, and Microsoft have already utilized these tools. Additionally, be transparent about your COVID-19 response. Consider how COVID-19 affects women, employees of color, and LGBTQ employees. It is clear that there is a disproportionate impact of COVID-19 on communities of color, specifically Black people. 70% of deaths from coronavirus in Chicago are among Black people, even though Blacks make up only a third of the city's population. Over 50% of the cases found in Milwaukee are among Black people. Asian individuals, additionally, have faced increased discrimination and have been the subject of brutal attacks. Be transparent about your response to police brutality. Employees and potential employees are evaluating whether companies are taking an active role in dismantling the structures of racism. Resist the urge to cut D&I programs amid COVID-19. Although companies are facing financial setbacks, resist the urge to cut them. Stephanie Sharp of Sharp Banks Manmer Law Firm states that we are going to see whether diversity and inclusion programs are in the DNA of law firms or whether firms view them as just discretionary. Now that we have attracted the talent, how are we going to interview them? Along with reviewing all relevant materials, resume, cover letter, etc., avoid independent research. Avoid social media. Avoid going to your acquaintances to learn more about these individuals. Keeping an open mind also means being aware of implicit biases, which are the attitudes or stereotypes that affect our understanding, actions, and decisions in an unconscious manner, positive or negative. Implicit biases are malleable. You have the power to interrupt them. For example, resumes with Black-sounding names receive 14% less callbacks for jobs than quote-unquote white-sounding names. Looking for a cultural fit can lead to people searching for candidates that resemble themselves. Everyone has implicit biases, but you cannot bring them into the interview room. Lastly, use a diverse and inclusive interview panel. It signals to the applicant that you, as a company, value diversity. Additionally, it allows diverse perspectives to be present in the decision-making room. When creating questions, make sure that your interviewers are trained. Make sure that you're seeking similar core information from every single candidate. Have a procedure on how to handle uninvited information regarding protected characteristics. And make sure notes from reference checks are not related to a protected characteristic. Appropriate questions should relate to the requirements of the job, elicit information regarding the qualifications you are seeking, obtain information regarding prior experience in education, and seek the reasons for leaving their prior employment. Examples of inappropriate interview questions are any questions regarding any protected characteristic and should be avoided. Questions such as, are you married? Are you a U.S. citizen? What is your native language? Are you affiliated with a church? These are all questions that should be avoided at all costs. And with that, I'll turn it over to Eric.
Thank you, Sky. One of the questions that we've had come in during just the first part of our presentation relates to this topic that you were just talking about. And the questioner asks if a business should be removing identifying criteria in resumes or in the interview process, doing sort of a blind resume review I know that, we've read some data about that, but I wonder, Sky, if you have thoughts about whether that's an appropriate or effective step for a business to take.
It can be. In this instance, we want to make sure that in the initial review of your resume, you should be conscious of how you're viewing these characteristics. And so, but to that end, additionally, these characteristics should be viewed as important when thinking about the entirety of the person. And so, in that instance, making sure when interviewers or when hiring managers are scrolling through whether it's pictures, things on LinkedIn, making sure to make a wide swath of applicants. But at the same time, when you're having a face-to-face conversation, it is important to note whether a person has been involved in a certain organization or a certain group, to make sure you completely understand the perspective of that person.
I think that's a good question and a great answer, and it gets really at the heart of what we're talking about in this presentation is how can you as employers balance the desire to attract and recruit and retain diverse employees, and this concept of, well, what if we simply remove identifying characteristics and conduct this as a quote-unquote colorblind process? That by itself is probably not going to be effective to address some of these systemic impediments that have been built into our system for so long. And I think that's a good segue to sort of the legal framework that we are going to recommend that we analyze these questions under. So, Sky has done a great job of showing us, sort of how we define diversity, steps we can take to identify and recruit those candidates. But the question many of you are going to ask is, am I allowed to specifically target diverse candidates? Am I allowed to advertise for diverse candidates? Or am I allowed to give a preference for diverse candidates? Or does that create legal liability for me? And I'll give you the shorthand answer from our perspective is that, notwithstanding the laws that we have in place, there are absolutely legally permissible ways for you to focus on recruiting and retaining diverse talent, and to do it in a way that does not run afoul of the law. Now I'll talk a little bit about maybe some of the potholes, and things that we can try to avoid as we work our way through that process. So the legal framework that we're talking about here, in most instances, are going to be the state and federal anti-discrimination statutes that you're all familiar with. At the federal level, Title VII, the federal statute that's administered by the EEOC, prohibits employers with 15 or more employees from discriminating against and engaging in any other adverse conduct towards employees on the basis of race, color, religion, sex, or national origin. There was a question that came in earlier during our presentation, and the question was, well, isn't there a protection on the basis of disability as well? Disability is a protected characteristic. We left that out of our list because it's specifically addressed by the Americans with Disabilities Act. And what's interesting is I'll mention in a few slides about how if we do this reverse discrimination analysis, there's actually going to be a different standard for a reverse discrimination claim under some of those other statutes as compared to Title VII. So Title VII, the overarching framework here protects employees not just in hiring and firing, but also compensation, terms, conditions, and privileges of employment. As I mentioned, the protected characteristics here: race, color, national origin, religion, sex. These are the characteristics that are protected under federal law, but it's important to note that many states actually have broader protections. As an example, in addition to the characteristics that we listed previously, many states also protect creed, color, disability, marital status, national origin, sexual orientation, arrest and conviction records, use or non-use of lawful products. There's a couple on this list that I thought would be helpful to highlight. One is the sexual orientation. Title VII does not specifically address sexual orientation. You may have been familiar in the last 6 months, there was a statute at the U.S. there was a case that went up to the U.S. Supreme Court on that very issue about whether Title VII grants protection on the basis of sexual orientation. That decision has not yet come down, and we don't know exactly what the outcome of that decision will be. But the takeaway is that even if the court ultimately determines that sexual orientation is not protected under federal law, Title VII, one of two things I think will happen. The first is I would anticipate that we might see Congress move towards legislation in that area. And notwithstanding that fact, many states already make discrimination on the basis of sexual orientation illegal. Another item I wanted to call out here, arrest and conviction records. Again, this is not a basis that is explicitly prohibited under federal law or under Title VII, but the EEOC has issued guidance and has taken the position that wide policies that prohibit or limit employment opportunities on the basis of arrest and conviction records can have an adverse impact on minority populations or communities of color. So this, again, isn't new news, but to the extent that you have a policy and a hiring policy that casts a bright line prohibiting certain individuals for applying based on arrest or conviction record, even if you're in a state where that is not explicitly prohibited, there's a chance that the application of that policy could be deemed by the EEOC to be a violation of Title VII. So I think the takeaway here is, in addition to federal law, be sure to be aware of what your state or local laws say in terms of that legal framework. We think about these anti-discrimination laws, Title VII state anti-discrimination laws, most of the time as laws that are protecting individuals who are in these different protected classes. Minority populations, people of color, people with disabilities, essentially folks who fall in these protected classes. But in the context of what we're talking about today, which is the desire to specifically target and recruit, support, advance individuals and communities of color, the question is, can these laws work the other way? Do I run the risk of catching a reverse discrimination claim if I am deemed to have shown a preference for somebody in a minority group in a hiring or employment decision? So we have our next poll question here, and I'm interested. This is obviously an anonymous poll here, so I'm interested in the attitude of the group here. The question is, have you had an employee claim reverse discrimination? And I guess what I'll say here is, when we say claim, let's say make a formal complaint, whether that be a formal complaint internally or file some sort of claim with the state or federal agency. Go ahead and answer yes or no, please. So the majority of us who've answered no, but 20% have experienced a claim of reverse discrimination. So that's a substantial enough issue that I think it's part of the reason we're talking about it today. And frankly, these are claims that have started to increase over the last several years and may continue to increase depending on the political landscape. Racism, sexism, discrimination, these are the systems in which a majority is able to enforce its power and privilege over a minority through political, economic, or institutional means. So that's why there doesn't seem to be a clear application here to this concept of reverse discrimination. There have never been a national set of laws or a system that's put in place to systematically oppress white people, or to push them to a status that is less than a minority group, for instance. However, we still see some individuals raising claims alleging reverse discrimination. As a threshold matter, under federal law, the case law and the statutes that have been developed make it clear that it is acceptable for public and private entities to have a goal of remedying past discrimination. And this is where we get into the context of affirmative action programs, federal contractors, or other entities that are subject to an applicable consent decree or statute may have the ability to implement an affirmative action plan. But the focus of those plans is that they are intended to remedy past discrimination. In instances where we are not operating under an affirmative action plan, instead, we're analyzing it within the context of what we looked at before, Title VII or state and federal anti-discrimination laws. So the argument would be, even if I am in a majority population, even if I'm white, Title VII specifically says that you can't take action against an employee on the basis of race or color or national origin. And so it is not explicit under the statute that a white individual, for instance, can't bring a claim under Title VII. And this slide contrasts that with the statutes under ADA, the Americans with Disabilities Act, or the Age Discrimination in Employment Act. Under those statutes, a claimant does not have standing to bring a reverse claim. So for instance, someone can't file a claim under the ADA and saying, I'm being treated less favorably than a disabled employee. Or under the ADEA, somebody who's under 40 is not able to bring a reverse age discrimination claim and argue that an employer is treating older employees more favorably. Contrast that with Title VII, which does, in its framework, theoretically permit this kind of reverse discrimination claim. There hasn't been a large body of law on these reverse discrimination claims on the basis of race in the employment context. So what we look to as we analyze sort of the framework that an employer should follow is some of the cases that were developed in the education context. One of those was the Bakke case from 1978. This is a sort of a famous affirmative action-ish case out of the University of California. And the court in that case held that universities could take race and ethnicity into account when making decisions regarding student admissions, but it prohibited them from using rigid racial quotas to increase minorities on campus. There was a question that we saw come in, which was, whether we're entitled to use specific quotas or percentages as targets. There certainly are those sort of metrics that are used in certain affirmative action plans, but if you're not part of one of those affirmative action plans, there is risk in using a quota or a target like that. And that's effectively what was established in that Bakke case in 1978. There was a more recent case addressing the same issue in 2016, and there was some question when this Fisher versus University of Texas case was decided about whether the court would change its position given the time that had elapsed since the Bakke case in 1978. But ultimately, the Supreme Court in the Fisher case upheld the admission system that the university system had in place, where consideration of race is contextual and does not operate as a mechanical plus factor for underrepresented minorities. The court explained that although admissions officers can consider race as a positive feature of a minority student's application, there's no dispute that race was but a factor of a factor of a factor in the calculus that the university used. So again, ultimately what we see is that the courts are upholding decisions on this basis as long as it is part of a more holistic analysis or more holistic process, focusing exclusively on the diversity characteristic is where the risk for employers lies. Notably, there is a stricter standard that applies for an individual who's bringing a reverse discrimination claim. The court has explained, the standard, a determination that the respondent is the unusual employer that discriminates against a traditionally favored class. So the law is recognizing that it is unique or unusual for an employer to actually discriminate against somebody who's in the majority. If a party doesn't have direct evidence of reverse discrimination, that party would have to prove that there was a reason or inclination to discriminate invidiously against the majority group, or evidence that this is, typical legal language, there's something fishy about the facts at hand. That person would have to show that they were meeting the employer's legitimate performance expectations, that they experienced an adverse employment action, or I suppose in the failure to hire process, or failure to hire that individual, and they were treated less favorably than similarly situated individuals who weren't part of the majority group. Two cases I want to discuss in this context. One of them is a case where there was evidence of what we'll call reverse discrimination and ultimately a resolution in favor of the plaintiff. That was a case brought by the EEOC back in 2011. The case was EEOC versus DOTS LLC. DOTS is a national clothing retailer. And ultimately, there was a class of 32 white applicants in that case who filed a group race discrimination lawsuit, or they brought a group claim, and the EEOC filed a lawsuit on their behalf. And the allegation in that case was that DOTS, the retailer, regularly hired black entry-level applicants for sales positions, but excluded white applicants who were equally or better qualified. That is a difficult thing to have to prove. What created an issue for DOTS in this case is that there was evidence that the store manager allegedly told one of the applicants that the store, quote, does not hire white people. So that's a case that ultimately DOTS settled, agreeing to pay about $250,000 and provide other injunctive relief to these class members. I would say that that is probably a very extreme example. If we're looking for cases that show us, how overt this sort of reverse discrimination has to be in order to be actionable, it's pretty unlikely that we're going to find a situation where an employer actually says it doesn't hire white people. But that's the sort of extreme conduct that has found to be actionable in this context. The other case I wanted to mention is one that you may have read about a couple years ago. It was a case brought by a male employee of Yahoo, the internet company, back in 2016 in federal court in California. The plaintiff in that case, Anderson, was a man who alleged that he was discriminated against, that he was denied promotions, and that he was ultimately terminated as a result of his gender. His argument was that Marissa Mayer, in her role as chief of Yahoo at that time, implemented a system that showed preference for female employees, female candidates and female employees, and that females were given opportunities for raises, promotions, and were not rated as harshly, and as a result weren't impacted by the employment reductions that took place. That case was ultimately dismissed almost entirely at the summary judgment stage. Ultimately, the plaintiff in that case was unable to prove that the practices that were put in place did more than simply create opportunities for women and actually cross that line into discriminating against male employees. And the other thing that I think created a very difficult and uphill climb for him was that based on the statistics, there was still an overwhelming number of employees at Yahoo who were male, a substantial majority of male employees in leadership and management roles. And from a compensation perspective, there was no data to suggest that men were being unequally treated. So those are the kind of cases that we have been seeing, and that's sort of the legal framework that we might analyze. But the question that you're going to ask is, okay, if I want to recruit diverse talent and retain talent, how far can I go without crossing the line to creating this risk? And there's some big picture takeaways that we've got here. Consider diversity as one factor in our overall assessment of a candidate. We're not hiring a diverse candidate based solely or primarily on their diversity, but instead, we're acknowledging that that diverse background is part of a life experience or other experience that makes them valuable to our organization. Have diversity goals rather than specific quotas or numbers. We talked about before how having those quotas or percentages that we're publishing or driving towards can create issues for us in the reverse discrimination context. Applying uniform standards across all characteristics. So, make sure that we're weighting things appropriately, and we can't, if someone is digging into our data, suggest that we are, unfairly creating a preference for folks who are in a minority class. and then utilize statistics to bolster our arguments. And this is a segue into some of the items that I'll talk about in the retention section, and also the items that Skye mentioned in the initial definition of diversity section, which is that there's all this data out there that talks about the value of creating diversity within the workforce, the economic positive items that come out of spending the time and energy to focus on diversity. What should we do if we're considering and we want to avoid this sort of adverse claim like Anderson had in that Yahoo case, where he said, well, I was terminated because I was a man and you treated women more fairly. This is the same advice that we're going to give you as employment lawyers if you're dealing with any sort of termination or any sort of risk, even if it weren't a reverse discrimination, right? An action should be well documented and obviously shouldn't reference a protected characteristic. We're not going to, have a different set of metrics to measure white candidates or male candidates. And then employees who, are going to be part of those decisions should be documenting them, taking adequate notes to explain the business justifications for the decision so that we can defeat this claim that it was reverse discrimination. The final thing that we've got in this section that is worth noting is the difference between diversity by itself and diversity and inclusion. And this is something that Skye mentioned at the beginning. Not only is this concept of diversity plus inclusion essential when we talk about what we're really trying to get at in terms of the culture that we're building in our organizations, but it also, frankly, strengthens our position to the extent that we're ever challenged from a legal perspective. If we're thinking just about diversity, maybe we're talking about quotas or specific monetary incentives based on protected characteristics, or making decisions based on diversity data without thinking about it in the context of our business needs. Whereas if we can include this concept of inclusion, talk about it's not simply about getting a candidate in the door, but it's about supporting that person, creating opportunities for them to succeed, mentor and sponsorship programs, and diversity certifications. We'll talk about that mentor and sponsorship concept in just a moment. Those are all areas that are going to make your program more effective and are ultimately going to provide you a stronger defense if you're ever challenged on the basis of reverse discrimination. So as Skye set it up at the beginning, we've identified the diverse talent. We've hired diverse talent. Now, what are some things that you can do to make sure that the folks that we have spent so much time identifying and bringing into our organization stick with us for the long run? So the final poll question that I'm going to pose to the group here is for you to tell us if you have a formal retention program within your company. If you could please go ahead and answer this. I'll give you just a few seconds. %75% say no. About 25% say yes. That's great for the 25%, and you shouldn't feel bad for the 75% because you're clearly in the majority here. We all know this is an area that we could spend some time working on. And what I will say is, it can be extraordinarily difficult for a business to get to the point where we are here, where we've identified diverse talent and we've hired diverse individuals, but this retention thing is really probably the most important part of this whole analysis, because you as an organization aren't simply looking to hire diverse individuals so you can say that you've hired them, but instead to create an environment where diverse employees want to stick around and that we support them and that we promote them and that we bring diverse individuals into leadership. I mean, that's a topic for a whole different presentation, which is, what are the things that we can do to support and advance diverse individuals? But this concept of retention and combating turnover is critically important. So, the statistics here are pretty extreme. Women are 2 times as likely to leave their job as men. In the tech sector, Black and Latino workers were 3.5 times more likely to quit their jobs than white or Asian colleagues. So, it's a stark problem to have to deal with. And there are clear business reasons why focusing on this concept of retention is really essential. You know, first, if we've been successful in identifying and recruiting and hiring excellent diverse talent, you know as well as I do that diverse professionals are always in high demand. A diverse individual is more likely than a non-diverse person in that same category to be recruited or poached by a competitor. You know, and many diverse professionals understand these. If we don't treat the diverse hires with respect and we treat them the way that we promised, these targeted diverse employees will start to listen to the external recruiters that they're getting calls from, sometimes from day one. And it creates a risk that all of the investment and time that we've made, you know, simply won't create the benefit that we hoped it would. You know, especially during that initial, say, 6-month period after we've brought a diverse employee on board, it's critically important for us to focus on assimilation. Most businesses don't have a special diversity onboarding program that covers that assimilation piece. You know, that really is the critical time period the data suggests when we talk about retention. You know, we can sing our praises and we can create the diversity brand that Skye talked about at first, and we can say all the right things to get somebody on board. But if we're not living up to those promises that we made during the recruiting process, you know, a talented, diverse professional who's going to have a lot of opportunities in the marketplace, you know, may decide ultimately that, you know, there are other opportunities that she may want to explore. Obviously, retention is the critical component if we want diversity at higher organizational levels, right? I mean, the data suggests that diversity has its greatest positive impact when it occurs at higher levels in our organization. Diverse new hires in lower level jobs can never be promoted or become senior if they leave before there is an opportunity for promotion. So that's a reason to focus on and invest time and money in this retention concept. So, you know, we've got some bullets here that talk about metrics, and that's what our advice is going to be, is to use data to support your retention efforts in the same way that you might use data in other areas of your business. You know, we could periodically survey our new diverse hires and diverse employees to identify the issues and concerns that they have. Work with your CFO to calculate the return on investment for our diversity program to ensure that a dollar impact of diversity is credibly calculated. You know, it's not impossible. Our numbers people will be able to figure that information out if we work with them. But having that sort of credible data to support it will simply continue to support our efforts in this area. If we talk about strategies, you know, even though we're talking about diversity as a concept in a presentation like this, understand that not all diverse employees are the same. We shouldn't simply think about lumping all diverse groups or even all individuals who are part of a single race or other protected category in the same group, but to develop sort of a personalized retention plan. And one of the things that we would like to see in a plan like that is to ensure that there's stay interviews. I'll talk in a minute about exit interviews, but this concept of stay interviews, where we're specifically carving out time on a periodic basis to check in with our diverse employees to ensure that they're getting the growth and recognition that they need to succeed. Our recommendation is that these sort of interviews happen at least twice a year. Stay interviews, super important. Exit interviews, okay? Even if we've been unsuccessful in retaining a diverse employee that we've recruited, the exit interview is a critically valuable piece of information. You know, that's where there's no longer a need for a positive reference from an employee's manager, and they're going to be willing to speak candidly. That's a scenario where we've seen the ability to get real, unvarnished data and information that can help us assess how we can improve. And then one of the bullets that we've got here is equipping our executives to manage diverse teams, or even beyond executives, supervisors or managers who are going to be the ones who are working on this retention piece. It's not enough for simply our HR teams or the folks in our organizations who are doing recruiting to understand these concepts. but it's also important for the individuals who are going to be supervisors or managing diverse employees to understand the importance and to be on the same page with these retention efforts. One of the data points I've got here is creating a program where we might measure or reward managers for developing and retaining diverse employees, right? If we are finding a way where we can measure that and valuing that retention for teams and giving managers recognition in that regard, that could be a more concrete way for us to reinforce our message. I'll use an example here of what our law firm, Husch Blackwell, has implemented over about the last 6 weeks. 6 months. Client relationship managers, partners who have a client and manage teams of employees, are now starting to receive reports that tell us the percentage of diverse attorneys who are working on our cases and working for our clients. There's not a specific compensation metric or anything like that tied to that at this point, but I've found that to be a real eye-opening experience, and I think that it will prove to be effective to bring forward in consciousness for partners who are making those staffing decisions that this is something that's important to us as a firm. We talk about it, and here's a way that we live up to that commitment. So measuring that data and communicating it. As I mentioned, using this data-driven approach, doing the survey work, that is going to be one of the strongest ways for us to ensure that we're answering the needs and answering the questions of our diverse employees. The last item here that I've got that I want to mention is effective sponsorship and mentorship. You may have heard this concept before, but there's a difference between mentorship and sponsorship. Many or most organizations have mentorship programs in place and may have specific mentorship programs for diverse employees. And that's a great idea, and that it's something that obviously needs to continue. A mentorship is somebody who can be a confidant and advise a diverse individual. But sponsorship is something that's a little different. Sponsorship is somebody that will advocate for that person, that will be the voice at the table, maybe when that individual isn't in the room, to sing their praises or to tell that group that we need to give this person an opportunity. And we see a gulf between mentorship and sponsorship when it comes to diverse employees. Many businesses and many diverse employees feel like they're getting opportunities for that mentorship relationship. But the sponsorship is something that we still do not see at the same level as we see it for white men. As an example, the Center for Talent Innovation did a study and said that the vast majority of women and multicultural professionals, both reporting over 80%, say that they need navigational support to advance their careers, but that they receive it less often than Caucasian men. The study revealed that more women than men have actually been assigned mentors, okay? But 15% more men won promotions. So that mentorship piece only gets us halfway. We need to think about that sponsorship piece as well. With that, I want to bring this section to a conclusion. I'm going to take a quick check here and just see whether we've got any other questions that we might answer before we have Skye bring us to a conclusion. There's a question here which says, would having state interviews only with minority employees create liability for reverse discrimination? That's a good question. I guess I'd be interested in Skye's thoughts as well, but my take is that that is clearly not an adverse employment action. That is not a hiring decision or a decision that impacts advancement or compensation, but an example of outreach to a diverse subgroup of employees. So I think it would be extraordinarily difficult to create a reverse discrimination claim based on that fact. Do you have thoughts on that as well, Skye?
Yes, I completely agree. It really comes down to the adverse action or the, whether it's hiring or firing when you're looking at reverse discrimination or discrimination in any type of discrimination. And so I agree. It would be incredibly difficult to really bring in action based on that.
Great. Well, with that, I think I'd like to just turn it over to Skye to share some final thoughts today.
Thank you, Eric. I just wanted to speak to everyone, all of our listeners today, that as a Black woman, these last couple of weeks have been incredibly difficult for me. Seeing the senseless killing of Ahmaud Arbery, Breonna Taylor, and George Floyd has impacted me deeply and caused emotions of fear, anger, sadness, and exhaustion toward a topic that isn't new, but has recently become more visible, especially after weeks of data showing the disproportionate impact of COVID-19 on the Black community. It is important to note that this experience is not unique to me. Many Black employees have similar feelings, yet must continue to work as usual. To those listening, I hope we can find a way to serve in solidarity and show our support to a community that is consistently underserved. We have a unique opportunity to change not only our individual actions, but structures of inequality within employment policies. It is not enough to not be racist. You must acknowledge and openly condemn acts of racism and injustice. I urge you all to reflect on your individual as well as organizational commitments to anti-racism work in order to take an active role in changing discriminatory institutional structures and dismantling white supremacy. All lives don't matter until Black lives do.
Thank you, Skye. Thank you very much for that. And thanks to everyone on the line for joining us for our program today. We hope that the information we provided was helpful for you and your organization. If you haven't already, please click the survey icon at the bottom of your screen to complete our short survey. Your feedback assists us in providing quality future programs. As a reminder, this program has been approved for credit, continuing legal education credit in Colorado, Illinois, Iowa, Kansas, Minnesota, Missouri, Nebraska, Tennessee, and Texas, and that CLE credit in Wisconsin is pending. The program's also been approved by the Illinois Bar for diversity and inclusion credit and by the Missouri Bar for the elimination of bias credit. You can report your HRCI, SHRM, or CLE credit in those states that I explained using the CLE widget at the bottom of your screen and by completing those questions. And now that our presentation is complete, you can download the certificate of attendance from that certificate widget for your records. A recording of the webcast that we did today will be available tomorrow for watching and sharing. When that is available, a link to that recording will be emailed to you. We've got your information by virtue of you signing up for this presentation today, so you'll receive an email with that information. This concludes our webinar. Thanks very much for joining us.